Katherine Peter's involvement as an informant in the investigation of Kearney's alleged crimes provides no substantial basis for reconsideration of this court's prior denial of the defendant's McCarthy/Odell motion. Kearney acknowledged in passing the existence of his prior motion to dismiss, but asserts that he filed it without access to undisclosed evidence which he claims was important. Bederow affid. $33. The defense designates two such pieces of evidence. First, communications between Miss Peter, Mr. Mello, and D.L. Tully. Bederow affid. 934, which was critical and if disclosed promptly, would have been included in support of the defense's first motion to dismiss. Bederow affid. 291, and second, the previously discussed presentation to the grand jury of excerpts 10 from Kearney broadcasts that were labeled by Lieutenant Tully. Bederow affid. 936. The defense claims that it learned of this for the first time on the 4th of September 2025. Bederow affid. 936. As fully demonstrated above, that contention is risible. It is true, however, that since the previous defense motion to dismiss, the defense has acquired communications among Special Prosecutor Mello, Lieutenant Tully, and Miss Peter, and so has new evidence. That being undisputed, the remaining legal question for this court is whether the significance of that evidence is such that substantial justice mass Crim. P. 13, A. 5, should dictate an undoing of Judge Doolin's previous denial of the defense motion to dismiss. It should not. There is a factual dispute that the court should resolve. The defendant paints Miss Peters as a member of the prosecution team, indeed, the dominant player to whom Special Prosecutor Mello outsourced investigative work. Bederow affid. 191. Per Bederow, Mello was supposedly aware that she edited Mr. Kearney's content with her own editorial slant and bias, and reviewed private links she sent him or days before the grand jury proceedings started. Bederow affid. $191. The implication of the latter assertions, apparently, is that Mello and Tully were spoon-fed maliciously edited clips by Miss Peter, which they then mindlessly regurgitated as grand jury exhibits. As Lieutenant Tully's affidavit demonstrates, that is not the case. See, for example, Tully affid. 20-22, 41-45. Miss Peter was not part of the prosecution team, but a source of information among many sources. The primary source of information was the victims of Kearney's broadcasts, who complained about them to the Commonwealth, although to be sure, Peter may also have brought some of that information to Mello's or Tully's attention. In each instance, Tully went himself to the internet, viewed the allegedly offending material, copied it if appropriate, and, if presenting it to the grand 3. On the one hand, the defense is highly critical of the Commonwealth as ignorant or dismissive of Peter's woeful credibility. Bederow affid. 9157, see also, for example, 141. On the other, it never fails to adduce the slightest boast by Miss Peter as to her own importance to the investigation as credible, for example, Bederow affid. FF, 193-196, 197. 11. Jury named it in a way that accurately identified its contents, usually using Kearney's own words as contained in the excerpt. Tully affid. #739, 44, 45. The defendant's bald assertion that the Commonwealth employed Miss Peter to clip, edit and rename Mr. Kearney's episodes and then conceal the actual episodes and their accurate information from the grand jury's consideration. Bederow affid. 208, is an outrageous and irresponsible untruth. In but two instances, the Commonwealth, of necessity, did use the exact videos provided by Miss Peter because those videos were no longer up on the internet, allegedly because they had been removed. Both were wiretapping claims. One arose in connection with an alleged surreptitious Recording of Lindsey Gaetani, which the defendant played on an internet broadcast. The evidence was that the initial version was taken down, and a second version substituted into which Kearney edited from some other source an announcement that he was recording the conversation. Gaetani's testimony corroborated that Kearney never told her the conversation was being recorded, i.e., the initial version, not the second, was genuine. The other Peter recording was introduced during the grand jury presentation involving Mr. Scanlon. In all, a defendant might well contest the authenticity of these, or any, recordings, but here the Commonwealth had a good faith basis for believing them to be accurate, based on the statements and testimony of the involved witnesses. See, for example, Bederow Affid. 4217, citing the 28th of November, 2023 GJTR. pp 14-15, Scanlon claimed that Kearney told him he wouldn't record their conversation. There was no impropriety in their introduction. Were the court to conclude otherwise, however, the proper remedy would be the dismissal of the resultant tainted indictments. That is unnecessary. The Gaetani indictment is not before this court. It was never part of 2382 CR 00313, and in any case, has been null prost, for unrelated reasons, by the Norfolk District Attorney's Office. Neither is a Scanlon indictment before this court, for as the defendant has complained repeatedly, the Commonwealth did not ask the grand jury to return 1:12. As for the indictments actually before this court, to the extent she and Mr. Kearney share a mutual loathing, and they clearly do, and to the extent to which she may desire to see him hurt, humiliated, and imprisoned, and she apparently does, the question for the court and ultimately a jury, should a trial judge permit counsel to go down that particular road, is not the bias of any particular informant, but the reliability of the evidence. The Commonwealth's evidence before the grand jury consisted of videos indisputably made by Kearney documenting his own actions and the testimony of his victims as to their knowledge of those actions and the impact they had on their lives. It matters not a whit who informed the Commonwealth of any particular video's existence. What matters is the authenticity of the evidence. For all the relentless characterization of Tully's labeling of the video excerpts shown to the grand jury as improper, Bederow Affidavit 9251, intentionally misrepresented out of context, cherry-picked snippets 9253, prejudicially named 254, false, lie, name, D, 9255, misnamed 1264, sliced and diced, definite, mem. P9, cherry-picked and out of context and subterfuge, that tricked the grand jury, definite, mem. 10p, nowhere. Nowhere does the defendant point to even a single word of Kearney's in any video clip that has been altered or modified by the Commonwealth. Nowhere does he point to a single instance where a word was omitted altering a meaning, and nowhere does he represent that he did not create the videos of his own actions and words shown by the Commonwealth to the grand jury. He does not make those representations because he cannot. At the end of 30 pages of memorandum of law, 88 pages of meandering argument mislabeled as an affidavit, and a host of exhibits, the defendant's contentions amount to nothing more than sound and fury signifying nothing. The Commonwealth has provided the defendant with extensive discovery in this case, whatever the problems or flaws in its production of discovery, and there have been some, they fall far short of requiring the draconian sanction of dismissal of the case. The Commonwealth promptly provided the defense with extensive discovery, as borne out by the items set forth in undersigned counsel's letter to Attorney Bradel of the 8th of May, 2024, also notable for 13. Its expression of undersigned's belief, naive in retrospect, that discovery was then almost complete. This court should take note of discovery itemized in that letter, the subsequent discovery Letter of the 13th of June, 2024, and indeed the Commonwealth's filed and docketed responses to the defendant's previous discovery motions, in measuring the veracity of the defense's claim that since Mr. Kearney's 2023 indictment, the Commonwealth has exhibited breathtaking indifference to its constitutional and statutory obligations to disclose evidence to the defense. Definite. Mem. p. 21. Discovery has continued since that time, with the Commonwealth responding to defense requests, and the defense, in turn, finding problems with the discovery provided, alleging missing discovery. Sometimes correctly so, continuously generating new discovery requests, and demanding further explanation of discovery already provided. Some of the Commonwealth's problems have been logistical, which are not the defendant's fault, but inform the realities of production. By way of background, the investigation into Kearney began about May or June of 2023. Tully affid. One attorney Mello, a resident of Bristol County, was engaged as special prosecutor on or about September of 2023. Tully affid. 6 months later. In March of 2024, the Norfolk District Attorney recruited the undersigned to assist Mr. Mello with some legal research, writing, and similar tasks. Mello, however, proved to be gravely ill and has been physically unable to appear in court, requiring the undersigned effectively to assume full responsibility for the case. In point of fact, the undersigned has never been able to meet with Mr. Mello in person since undersigned counsel's entry of an appearance in any case against Mr. Kearney. Cosgrove Affidavit 43-4. While counsel has largely been able to obtain discovery materials directly from the Norfolk District Attorney's Office, some of the necessary materials have been in Mr. Mello's possession, and his ongoing health problems and intermittent hospitalizations have retarded the process of acquiring them. See, for example, Cosgrove Affidavit 16. To return to the previously mentioned the 8th of May, 2024 discovery letter, the court will note that in addition to the discovery produced by undersigned counsel, it references discovery previously provided by DT Lieutenant Tully, given 14. Mello's illness, then hoped to be transitory, Tully was employed in the prosecutor's normal role of providing discovery. Another difficulty with discovery in this case has been the ongoing nature of the defendant's conduct toward the alleged victims and witnesses. To reiterate just a few previously brought to the attention of this court or others, there was his online hope that Lieutenant Tully would die horribly, along with his wife and children, charmingly coupled with Kearney's self-comparison with Jesus, his nose-to-the-window antics and accusations in the form of questions at the Albert's Pizza shop, captured by their security camera, his recent drive-by outside the Cape Cod home of a witness in the Karen Red case, his discourse as to whether or not an officer's wife was blue because, Kearney speculated, she gave her husband oral sex, and his repeated libels of Jennifer McCabe as a murderer. These, and a host of other antics, some relatively minor, some offensive but clearly legally protected speech, prompt the victims to contact the district attorney's office, often by email, questioning whether action can be taken, whether the conduct is a bail violation, etc. Arguably, these constitute discoverable statements although they say nothing whatsoever about the crimes with which the defendant is charged. To the extent they provide information on subsequent bad acts, the Commonwealth would be obligated to disclose such bad acts in any case before attempting to admit them at trial. If statements are otherwise arguably discoverable, it is because they show a bias against Mr. Kearney that conceivably could be used to impeach him, but the reasons for any victim's bias are obvious from the very facts alleged supporting Kearney's charges. In that sense, discovery of the statements is entirely cumulative. This court should consider limiting discovery going forward to exclude victims' statements that make no factual references to the underlying charged offenses or to prior or subsequent bad acts that the Commonwealth seeks to introduce at trial. Otherwise there will be no end to it. As it did with its attack on the grand jury presentation, the defense focuses much of its criticism on the Commonwealth's provision of discovery concerning Katherine Peter, which, it 15. claims, support its preposterous theory that she, Lindsey Gaetani, Mr. Mello, Det. Lieutenant Tully, and possibly others diabolically plotted to have Mr. Cleary's bail revoked by luring him into intimidating Miss Gaetani after they made her what Mr. Bederow describes as a witness-taking. Care to put the term in scare quotes. Discovery provided by the Commonwealth shows that Gaetani was indeed a witness, interviewed by the police with specific attention to what she knew about Kearney's ongoing communications with Karen Reed. After that interview, she received a summons to testify before the grand jury. Like so many other issues, the defendant has raised this one with this court before. The Commonwealth picks up the story by quoting a previous response. In abbreviated form, the Commonwealth summarizes the evidence, largely drawing on Ms. Gaetani's testimony before the grand jury, supplemented by police reports and other evidentiary materials, all of which have been provided in discovery to the defense. Ms. Gaetani met the defendant in September of 2023 after viewing his blogs and YouTube shows dealing with the Karen Reed case and ordering a t-shirt from his website. The relationship became intimate. By the beginning of December, the relationship had soured. Gaetani came to the attention of Special Prosecutor Mello, who dispatched Det. Lieutenant Brian Tully and a specially assigned private investigator, Nelson de Gouveia, to interview her. As a result of that interview, the detectives returned to Gaetani's home on the 22nd of December, 2023. Upon receiving the summons, Gaetani feared that Kearney would think she had sought out the detectives and was trying to get him in some sort of trouble. She was afraid he would retaliate in some way. She called Kearney and sent him a picture of the summons. Hours of phone conversations and text communication ensued. Kearney became upset and accused Gaetani of setting him up by passing along information to Kate Peters, a woman who, he believed, was averse to his interests, and had provided the information to the police. The following day, the 23rd of December, acting against what he had told Gaetani was his lawyer's advice, Kearney announced that he wanted to come by Gaetani's apartment to discuss the summons. Gaetani agreed. They met first at a business conference room in her apartment building. Upon arriving, Kearney demanded that Gaetani give him her phone. He said he wanted to read any messages between her and Peters, as well as any messages with Detective Lieutenant Tully and Special Prosecutor Mello. Gaetani refused. The defendant then threatened that his lawyer was going to have to destroy her on the stand, tear apart every piece of her life, embarrass her, bring up everything from her past. Stalling for time, Gaetani went into the bathroom and telephoned Special Prosecutor Mello and spoke to him briefly. Mello called Lieutenant Tully, told him Gaetani said that the defendant was 16 in her apartment, and forwarded her call. Tully could not understand anything she said as the voices were muffled, inferably because Gaetani did not want the defendant to overhear. After several minutes, the call ended, and at 10:48 p.m. Gaetani sent Lieutenant Tully the following text message: "Ken said to call you but I can't, he's knocking on the bathroom door. I have to go back out. Please don't text or call and tell Ken not to because he wants to see my phone. I'm deleting our calls and texts right now. Don't respond until you hear from me, please." Gaetani emerged from the bathroom and unsuccessfully attempted to stall, showing the defendant her phone. Terrified by the defendant's threats, Gaetani acquiesced, and the two proceeded to her apartment. In the course of the conversation, the defendant instructed Gaetani to delete from her phone messages between the two of them. He said that I would not get in trouble if wanted to throw my phone in a river or delete any messages. because with this summons there was no order for preservation of evidence. So he said I could not get in trouble for removing any incriminating information from my phone about him. He said that he confirmed this with his attorney, Tim Brad. For the next several hours, the defendant went through Miss Gaetani's phone, reading through exchanges between Gaetani and Kate Peters, and taking notes. At the conclusion of this process, the defendant announced that he was very proud of her and was going to protect her. The reconciliation, such as it was, did not last long. Later, while the defendant's attention was elsewhere, Gaetani ripped the page of notes that he had taken from his notebook, crumpled them, and shoved them down her shirt, and subsequently hid them under her mattress. Footnote. Omitted. The defendant became aware that his notes were missing and demanded them back, accusing her of stealing his property. Eventually, he announced he was leaving, and after some delay, did so. Gaetani recounted these events the next day by telephone to Lieutenant Tully, who told her to call the Meadfield police to report the incident. Tully perceived her to be hesitant. He called the Meadfield police, reported what Gaetani had said, and asked them to follow up. The defendant has complained repeatedly that the phone texts of that evening between Gaetani and Tully were not included in the subsequent copy of the download of her phone provided them by the Commonwealth. Undersigned counsel explained why that was the case in his letter to Attorney Bradel of the 8th of May, 2024, telling him in pertinent part, if there is data missing, that is because it was missing when the phone came into the Commonwealth's possession, custody and control, and thus we do not have it. The Commonwealth later secured the missing texts with Tully. 17. By means of copying them from his cell phone, and handed them to counsel in open court during a hearing. So in sum, the defendant wishes to tell a jury that the Commonwealth engaged in a plot with Kate Peter and Gaetani to make her a witness, then lure him to her apartment, provoke him to criminal conduct, then arrest him so his bail could be revoked. So cunning were the alleged plotters that Miss Gaetani studiously avoided any mention of their plot and its apparent progress when texting Tully, nothing like, it worked or he's here now, arrest him. Oddly, neither Tully nor any other officer was outside Gaetani's apartment, waiting to burst in and arrest Kearney at the appropriate moment, and not incidentally, protect Gaetani from any harm. Equally oddly, Gaetani never reported the incident to the local police the following day, a lapse that prompted her alleged co-conspirator Tully to make the call. Truly, this defense theory is Lincolnesque, at least in the sense that Lincoln has been quoted, likely falsely, as saying, you can fool all of the people some of the time, and some of the people all of the time. So, yes, obviously the defendant is correct that the Commonwealth thinks little of his theory. But indulging the defense's contention that the Peter discovery was required irrespective of the Commonwealth's subjective belief in the reliability of the evidence, and further assuming arguendo that its conspiracy theory would be an admissible defense against the now dismissed Gaetani indictments. How probative is it of the indictments before this court, where Gaetani is not a victim? The video evidence against the defendant was the product of his own hand. Kate Peter did not organize, participate in, or induce the defendant to organize, participate in, film, and broadcast the rolling rallies in which the defendant led a caravan of cars to the doorsteps of witness, harangued them and intimidated them using a bullhorn. Neither did Kate Peter compel the defendant to dox and defame witnesses and their family members. The defendant did that all on his own. And a copy of Lieutenant Tully's recorded call was provided to the defense in discovery. 18. To what extent has the defendant been prejudiced by any delay in disclosure of the Peter discovery, as he repeatedly asserts? If prejudiced at all, he has not shown it. The defendant also has a related complaint concerning discovery concerning Miss Peters, i.e., the Commonwealth's alleged failure to preserve exculpatory evidence. The Commonwealth provided in discovery various emails sent by M.S. Peter, some to Mr. Mello, some to Lieutenant Tully. Certain of those emails contained links, usually, judging by label or context, to various online broadcasts by the defendant. Tully's general practice, by no means exclusive to him, was not to access links in unsolicited emails sent from parties outside the NDA's office/criminal justice network. Mello, on the evidence of one response to a Peter email suggesting he was unable to access the content, apparently did zero, at least on some occasions. The emails remain, but not all of them have links that are active. They have not been successfully accessed by undersigned counsel, and Tully and defense counsel also report that those links are dead. Why they are dead is wholly speculative. Possibly the path expired of its own nature, or was removed by the sender. None of the emails at issue contained any warning to the recipient that the links were time-limited. The factual scenario raises some novel legal questions. For example, what duty does an agent of the Commonwealth have to access an unsolicited link, conceivably exposing computer networks to malware? If the link, which is essentially an electronic path to another document, is not accessed, was the unaccessed document ever in the Commonwealth's actual possession as expressed in definite mem. At 28. If the link is accessed, absent some notice that access may become unavailable in the future, does the Commonwealth have an obligation to attempt to preserve the contents of the link in some other form as a precaution? Does that obligation, if it exists at all, vary depending on the contents of the link? For example, if someone sends an unsolicited email saying that a defendant looks a lot like Humphrey Bogart and attaches a link to Casablanca, is it sufficient simply to save the email, or must the Commonwealth download and preserve a copy of Casablanca? Does the content 19 of Casablanca constitute part of the statement of the witness, or is the statement simply her own words, or her own words and the fact of her attaching Casablanca, irrespective of the film's actual content? Where the link goes dead without any action by the Commonwealth, has the Commonwealth lost evidence or destroyed it? Finally, if someone forwards another email, or a newspaper article, without adding any content, or alternatively, adding neutral content, such as FYI, does the mere act of forwarding it constitute a discoverable statement? If the defense has pondered these issues, it gives the court no hint, proceeding immediately to the assumption that much of the undisclosed and now destroyed evidence was favorable Gileo material because it undermined Miss Peter's credibility, demonstrated her bias against Mr. Kearney, and supported the defense's theory of a shoddy, bad faith investigation. Definite mem. At 28. Given the difficult nature of the novel legal questions raised above, the most useful line of analysis may be to assume, arguendo, that the Commonwealth had a duty to access the links and to take some measure beyond preserving the emails that contained them as a prophylactic against their possibly becoming dead links. The court can then proceed to more familiar questions, i.e., was the evidence once available at the links favorable to the defense? If so, how damaging was its loss, and in light of the damage and the Commonwealth's culpability, what should be the remedy? Under Brady v. Maryland, 373 U.S. 83, 1963, even after the court is satisfied that the Commonwealth lost or destroyed evidence, the defendant is not entitled to relief unless and until he first establishes to this court's satisfaction a reasonable possibility, based on concrete evidence, rather than a fertile imagination, that access to that evidence would have produced evidence favorable to his cause. Commonwealth v. Neal, 392 Mass 1, 12, 1984, quoting State v. Missioner 25 or App. 523, 532, 1976. Here, the defense asserts that the missing evidence was favorable because it allegedly demonstrated bias by Miss Peter, and supported the defense's theory that the shoddy, bad faith 20 Investigation relied upon a civilian who despised Mr. Kearney and had a documented history of falsifying evidence against him. Definite. Mem. 28. But none of that is true. Given, as the defense says, Peter's cooperation with the Commonwealth and her dislike of Kearney, it hardly seems probable that she sent links to evidence she thought exculpatory. The reasonable and probable inference is that she sent links to Kearney's own broadcasts, which she thought to be inculpatory and pertinent to existing or possible charges against him. Thus, the defendant wisely makes no argument that the content of the missing links is exculpatory, but fiercely asserts that they demonstrate her bias against Kearney. The inference must then be that bias is demonstrated either by the content of the messages containing the links, but note that the defendant quotes none, or the mere fact that Peter was providing evidence to the Commonwealth, even if that evidence were probative of guilt. But there is nothing damning in any citizens assisting a police investigation by providing information. Rather, Miss Peter's lack of credibility, if such there is only demonstrated by the defense's parade of her prior antagonistic statements against Kearney and what it terms her documented history of falsifying evidence against him. Definite. Mem. 28. None of this comes from the lost dead link evidence. If, unlike here, a defendant meets his threshold burden as set forth in NEA, the court then applies a balancing test to determine the appropriateness and extent of remedial action. The court must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. Commonwealth v. Willie, 400 Mass 427, 432, 2000. That test does not require the Commonwealth to prove good faith or earnest efforts to preserve the evidence. Commonwealth v. Olszewski, 401 Mass 749, 755, 1988, SC, 416 Mass 707, 1993, cert. Denied. 513 U.S. 835, 1994, quoting Willie, Supra at 432. However, this court need not proceed to that test. For no consideration of government culpability or materiality need occur unless the exculpatory nature of the evidence is shown. Commonwealth v. Williams, 455 Mass 706, 718, 2010. 21. Should the court disagree, considered in the light least favorable to the Commonwealth, the analysis is as follows. Culpability of the Commonwealth. The Commonwealth delayed unduly in providing requested discovery of certain emails to the defendant. At some point, links in some of those emails went dead, whether during the period of undue delay or earlier is unknown. The Commonwealth has not been shown to have been aware of the likelihood of the links going dead, but it has been shown not to have engaged in any affirmative measures to counter such a possibility. At most, negligence, but no bad faith. Materiality of the evidence, none shown, though relevance to impeachment of Kate Peter is claimed. Prejudice to the defendant, little or none. The Bederow affidavit and definite. Mem. Overflow with purported examples of impeachment evidence the defense already has to introduce against Kate Peter. Should the trial judge allow such evidence against a witness, the Commonwealth has no need to call I to prove its case under the pending counts of this indictment. At best, the missing evidence is entirely cumulative. In supporting the opposite view, the defendant relies on Commonwealth v. Woodward, 427. Mass. 659, 678-79, 1998, which undercuts, rather than assists his cause. There, the Commonwealth failed to preserve from an autopsy a missing piece of an infant's dura that was subject to a preservation order. /D at 678. The Supreme Judicial Court upheld the trial judge in holding that the loss of that evidence, surely more explicitly defined and potentially helpful to the defense than that at issue here did not justify dismissal of the indictment. JD at 681. The Woodward opinion then cited Commonwealth v. Sinelli, 369 Mass. 197, 210, cert. Denied, 464 U.S. 680, 1983, for the proposition that, a. absent egregious misconduct or at least a serious threat of prejudice, the remedy of dismissal infringes too severely on the public interest in bringing guilty persons to justice. If and only if the defendant has satisfied his threshold burden and the court then proceeds to consider a remedy, based on the above analysis, the Commonwealth respectfully suggests that no 22 remedy is required, but again, should the court disagree, surely any remedy should fall far short of dismissal. The defendant's motion to disqualify Attorney Mello need not be addressed, as the issue is moot. Kearney indicated that one request is his never actually filed motion was the disqualification of Special Prosecutor Kenneth Mello. Bederow Affidavit, 1, c. The defendant's memorandum of law, however, while commenting frequently on Mr. Mello's alleged failings, never addresses this request. There is a point I arguing impairment of the grand jury process, and a point 2 arguing failure to properly disclose exculpatory evidence, but no point 3. Perhaps twixt the affidavit and the remo, the defense decided to abandon the argument, in which case, the court need not rule on it. However, the issue is moot anyway. The copy of Judge Doolin's memorandum of decision on the defendant's prior motion to disqualify Special Assistant District Attorney Mello, paper 99, as forwarded to this office by the clerk, bears the docket numbers of both 2482 CR 00043 and 2382 CR 00313. Degree The plain result is that Mr. Mello has already been disqualified on the matters pending before this court, and the new motion to disqualify is superfluous. The Commonwealth has not sought to appeal Judge Doolin's decision. During the early months of Mr. Mello's disability due to illness, the district attorney, Mr. Mello, and undersigned counsel hoped that he would soon recover sufficient health to play an active role in court. In explaining his decision, Judge Doolin stated that Ada Mello, in receiving communications from a witness while the alleged crimes were being committed, made himself a potential witness in Kearney's case. Apparently, the judge's explanation was insufficiently damning for the defense, which seized the opportunity to recast it for this court as follows: Mr. Mello's involvement in this scheme I.e., the alleged plot to frame Kearney for witness intimidation and have his bail revoked, was so great that it resulted in the court disqualifying him from the prosecution of the 2024 indictments in which Miss Gaetani is the alleged victim. One may look long and hard at Judge Doolin's decision without seeing a statement even remotely suggesting what the defense avers under penalty of perjury. 23. Proceedings, well over a year has passed, and that hope has not been vindicated. Moreover, there is no likelihood that Mr. Mello will be capable of appearing in court in the coming year, either as an advocate or in any other capacity. Bowing to these harsh realities, the Norfolk District Attorney and Mr. Mello have not entered into a renewal of his expired contract. Conclusion. For the reasons set forth by the Commonwealth, the defendant's motion to dismiss, as apparently incorporated in the Bederow affidavit, should be denied, with the exception of the defendant's prayer to disqualify Attorney Mello, which the court should take no action on, as the issue is moot. Respectfully admitted. S/Co. Cosgrove. Roberts.
Alright. I have a lot of thoughts. Let me just tell you right now, this is outrageous. They're going to lose. The state is going to lose this motion. And they deserve to lose. This is a clusterfuck. Oh my God. There in really deep. Let me try to do this rationally. Let me do it quickly. We're not playing trivia. I have to do things later today. I'm sorry. Allie, if you're still here, I promise you we will play trivia. If not on Thanksgiving Day, people will be busy. If we don't do it tomorrow after dinner, we will play Friday, okay? I think I don't have anything till Friday afternoon. I have doctors Friday. I didn't even know doctors were open on Friday. Let's focus. Oh, my word. My name is Grant Smith Ellis. If you missed the filing that just went up by the state in the Aidan TurtleBoy Kearney cases, the 2023 indictments involving Jen McCabe, Brian Albert, Julie Nagel, etc. Folks, something is deeply, deeply wrong. First of all, I'm not a lawyer. There's not legal advice, and that applies to this entire overview. They're screwed. Before we even get to some of the just blatant falsehoods in this response, let me just tell you, if there's an actual judge that reviews this factual record, first of all, this December 5th hearing is not happening. He needs time Cosgrove has to address the supplemental affidavit because it undercuts everything he says in this motion response. The state is in so much trouble. It's really the Norfolk DA and Kate Peter. This is the big secret. Kate Peter compromised these cases, and the Norfolk DA was trying to kind of slowly unpeel the onion to just isolate, contain what she touched, get rid of all that, and keep anything she didn't. But they're wrong about a lot of the issues of fact here, which are going to imperil this fucking case. I'm telling you, this is the most outrageous thing I've ever read from any prosecutor ever filed anywhere. And that's saying something. We just keep upping the bar. This is outrageous. So first of all, let's just set aside the Ken Mello thing. Both sides are agreeing he has ill health and is recused. Just let's set that aside for a second. The key issue here, okay, is one, Lindsey Gaetani is still a witness on the other cases, on these active cases, even though the two indictments involving Lindsey were dismissed. Number two, Cosgrove made this argument from the perspective that Kate Peter only touched evidence used in the indictments involving Lindsey. That is wrong. I don't know if he was withheld information or if he's just misleading the court. There is evidence she was involved in both investigations. Third, Cosgrove is an adverse party in a lawsuit with Lindsey, and he's attacking her credibility in here while buttressing Kate Peter's credibility, and he's wrong about the facts he's using to attempt to discredit Lindsey, and he's wrong about the facts he's using to buttress Kate's credibility. This is like living in fucking bizarro world. Okay? One, the messages from Tully to Lindsey and from Kate to Lindsey that were removed from Lindsey's extraction were from after December 23rd, some of them. Second of all, you just represented to the court that no messages exist between Tully and Lindsey and between Kate Peter and Lindsey that were removed from the extraction. You're out of your mind. That alone is going to bang you up on this whole thing. And then second of all, it's so petty. You try to undermine her credibility about Lindsey's credibility about that, and you're wrong? The gall of these people. Okay, that is one prong of this, okay? The second prong is their whole argument. They spent 6 pages trying to rehabilitate Kate Peter's credibility. Let me just tell you. First of all, they called her an informant. And I know folks are a little confused. Go to page 11 out of 26, page 10 of the document, numbered. Look at this header. that is a section header that says Katherine Peter's involvement as an informant in the investigation of Kearney's alleged crimes provides no substantial basis for reconsideration of this court's prior denial of the defendant's McCarthy Odell motion. What he's saying there is he's stipulating that she was an informant. And people say the phrase giving information. That is a freaking informant. He tries to recast her over and over and kind of equivocate between her and other people that were sending Tully information. No. We already have the Discord emails where Morrissey was on Kate's server. We have the message where Kate says, pursuant to the call with Ken Mello, Kate will do X, Y, and Z. Listen, they're trying to get this case so that Kate and Mello don't get called into it. And that's why they dismissed the Lindsey cases, because it would have been unavoidable. The only reason, in my opinion, they kept the 2023 cases alive was, one, they want to keep pressure on Kearney, and two, because they think they can make it so that Kate and Mello won't come up in that context, and they think they can keep Lindsey out of it. That's why they freaked out when Lindsey started providing information to the defense, because Cosgrove filed this motion, notwithstanding everything that's been coming out on social media. And if the judge gets wind of what Lindsey's been posting and the evidence that exists that contradicts Cosgrove's statements of arguments and statements of fact and representations in this motion as an officer of the court, the least Cosgrove has to worry about is these getting dismissed. They went all in for Kate Peter here. And mostly Tully, but Kate Peter, listen, she's way high. She's way more important to all of this than anyone's realizing. You don't do this kind of stuff. You don't do this kind of stuff unless you're going to bat for your person. And you don't go to bat for Kate Peter over 6 pages more for no reason. It's because they're trying to, the state, Norfolk DA through Cosgrove is trying to carve out areas of this case that Kate didn't touch. Oh my God. That alone is a huge violation. I don't know if folks understand. That's almost as bad as possible, because it means you know that Kate was involved in the 2023 cases too. You're just hoping that doesn't come out. And it did. So just Cosgrove's, and the other thing is Cosgrove citing cases about the interpretation of Rule 14 from before the changes to Rule 14. He's citing stuff from like 2008 or something, 2003, where was it? When we actually get to the legal argument. Right, when he's talking about the novel legal question of what he has to turn over about Kate, and then he starts talking about Casablanca. I love the movie, but it's irrelevant. Kate wasn't sending Tully messages about Casablanca. Kate wasn't calling Ken Mello about Casablanca. They were out. Kate wrote an email that's now out there. That's why he's fucked. Cosgrove is fucked 6 ways from Sunday, because Kate sent an email to Mello saying, pursuant to our conversation, here's a legal strategy to pursue with Kearney. Bro, she wasn't sending him Casablanca. If Kearney didn't get that in discovery from the state, and he got it from Lindsey, because Kate sent it to Lindsey for some stupid reason, because Kate doesn't think a lot, in my opinion. That's it. Ball game. Because that fundamental prong of the whole argument, pages and pages and pages, it falls down. My word, it wasn't innocuous. And it's not just exculpatory. The question before the court is not, it's not just that two-prong test. Rule 14 was amended. So when he's citing Commonwealth v. Willie from 2000, Commonwealth v. Oleski 93, 94, 2010, fine. The changes to Rule 14 went into effect in March of 2025. Yeah, March 1st or something. So what are you talking about, Cosgrove? They're going to lose this motion. I don't know how badly they're going to lose it, but let me just tell you, I can read between the lines here. The thing the state fears more, the Norfolk DA fears more so than anything else, is Kate Peter having to take the witness stand. Wow. I mean, I'm somewhat just shocked, because that's what it all comes down to. The prosecutorial misconduct wasn't necessarily Tully. He was just an intermediary. It was Kate. These cases can't survive Kate having touched any evidence that gets before a jury. That's what this whole argument is about. You got to really, really cut through it. But part of it was about how Lindsey was being used as an unwitting honeypot. But more of it is how Kate's role was hidden. And so they don't even like disclosing it in here. Look how passively they talk about it. Kate being an informant. They're like, oh, well, she provided information like anyone else. Bullshit. They're hiding the stuff about Marty Kraft. I know it. Bro, she can bring their... They went to bat for her. Listen, how Bederow responds to this. Does he get like a reply to the... Does he get a sir reply to their reply? How Bederow responds... Listen, Bederow's going to tear this apart. And listen, I am unbiased here. I call it like I see it. Bederow is going to rip this to fucking shreds. Okay, first of all, if Bederow didn't have the new information that he had, he would have ripped this to shreds. What Bederow has that's been come out online alone, not to mention the stuff in Bederow's supplemental affidavit that Lindsey turned over. Ball game. Ball game. I don't even know what ball game means here. What do you do in this case? Listen, I think I've learned that if this is really bad, they're just going to no-pross it, okay? But the thing with no-prossing it is, all of this is out there now. Why didn't you just no-pross it before making this fucking argument? It must have been because Cosgrove had this written before all this new information came out about Kate's ties to the Norfolk DA. It's over. You may as well no-pross it. You cannot come back from this. Forget about wheeling and dealing with Kearney. You cannot come back from this. You cannot win. At all. And I want folks to understand that's the big secret. It was that Kate has a lot of power because she was an informant for the Norfolk DA and the MSP, and they were protecting their case, and they kept having the situation where if they revealed what Kate was actually doing, none of this stuff could have got to trial. Eventually, they probably were like, oh, well, we can no-pross Lindsey's charges, and that way maybe Kate won't get called as a witness. Bro, how can you be so bad at life? Know the fucking factual record. You know what your fucking people were talking about. Oh, my God. I'm baffled. This is so bad. This can't go before a judge. What are they going to do? What are they going to do? Well, Your Honor, when we wrote that motion, I guess that email fell under the chair. The one from Kate Tomello. It just fell under the chair, Yeah. Oh, and, when we said that Lindsey deleted the messages, we meant that it was actually Tully when he had the extraction. He forgot to click a button. What the fuck are you going to... This is outrageous. I mean, it looks... See, the thing is, it's a little, there's some obfuscation here, because it looks like this, erudite, flowy, what did he cite to? This man was citing everything from Casablanca to the guy who wrote The Ballad of Dorian Gray, Oscar Wilde, or whoever the hell he was citing. This man was taking us on a history trip, all right, through the 19th and 20th century. No disrespect to him. I like history as well. You don't have to quote fucking Oscar Wilde, bro, in a motion in 2025. You don't have to fucking... What else did he fucking reference? Casablanca. You referenced it 5 times in a single fucking paragraph. Not necessary. It looks... What's really funny about this motion is it looks erudite. But it's substance. They're going to get torn the fuck apart. Forget about on the misnaming of the videos. That's not the sum and substance. What this makes me realize is you got to start page 10, section editor. That's the whole thing. The whole kit and caboodle is whether Aidan's earned reconsideration of his previously denied McCarthy and Odell motion, which I talked about before the stream. There should be a hyphen after Odell, after O there in Odell. Because of new information about Kate Peter. Oh, this is so brutal. These people are brutal. They saw this coming. They were like, oh, he's going to do a renewed McCarthy and Odell motion and we can preclude it. Our best argument will be if we just argue mootness because the Gaetani charges are gone and Kate maybe handled information in that case, but, we'll just argue it's moot. Oh, bro, and then you make this argument, and then he takes forever to write based on the timing. He was late. So Cosgrove makes this argument, and then as it's all prepared, he's got to be he had this ready at the beginning of this week, getting ready to file it. All this shit, it's the internet, and they're in this position where they're like, what the fuck, do we file this? We're 4 days late. That's why they waited 4 days. They were like, we can't file this. And they did anyway. Oh, my God. Listen, they must be so committed to Kate Peter. You just tanked this whole case by filing this, folks. They should not have done this. Because, again, this you have to think after the fact. All of this new information is out there that's in Bederow's supplemental affidavit that just, not to mention what's on social media, that eviscerates the core prong of this argument, which is whether or not Kearney's entitled to reconsideration of his prior motions to dismiss under McCarthy and Odell, which, as we know, if you were here earlier, has to do with... Forget members of the prosecution team, bro. You got to think about Rule 14's reinterpretation and what that means about people in the orbit of the prosecution team and PIs and informants and all that shit. Cosgrove didn't even disclose that she was working for Marty Kraft as a PI. She's not a civilian. Bederow got that wrong. She's a PI who's registered. I don't know if she was working with a license or under a license. She was a PI for Marty Kraft, who knew Tully. This whole case hinges on, oh my God, that's why they're all losing their mind. It's Kate. It's all Kate. Aidan may be a beneficiary of some of the attacks against Lindsey right now. I don't even know if he sees how many people are actually working for Kate who are pretending to like Aidan. That's one possibility. My point is, it's all Kate. These cases hinge on Kate Peter's involvement being disclosed with all the related to all of this. And the way, I don't know what Cosgrove is going to do, because his entire argument is that he didn't have a duty to disclose anything more to Kearney or anything about Kate Peter or her role related to anything, because basically Cosgrove's arguing Kate was really only involved with being an informant for Lindsey's cases. I'm paraphrasing. That's his argument, okay? But the problem is, if there's an scintilla, an indica, small indication of evidence that Kate was an informant related to the 2023 cases, then this whole argument collapses, and that's the evidence that fucking came out after this motion was drafted, clearly. They're pot committed. So why would you submit this? Why would you have him file this on the 24th, 25th, when all this shit came out over the last week? This is crazy. I can't believe this document was filed. I cannot believe it. It's already undercut. This document is moot. Not just moot, it's exposed. Reading it, I was like, oh no. Oh, you didn't just say that. Oh no, he did it again. Like, oh my God. He's going to lose all credibility. If this new judge on the Kearney case, is down the middle, the DA is screwed. All right, because immediately Cosgrove's going to lose all credibility. I realize I know this fact pattern pretty well, so it's going to be, you really got to get caught up if you're a judge on this case. I'm just an independent observer. I'm not a lawyer. This is not legal advice. Cosgrove made at least 5 to 6 material misrepresentations, inadvertently, I don't know, to the court here. All right, at least 6. At least, and they're substantive. And almost all of them are related to Kate Peter. And I now see it. Oh, I'm fucking pissed. Because I should have been able to fucking see it earlier. First of all, these people don't know how fucking Rule 14 works, so they're not even doing this right. Their whole plan was to try to keep as much evidence away from Kearney as possible and the court, so that charges could survive, even stuff coming out about Kate Peter's role in handling evidence. That's why they no-prossed the Lindsey cases. They used the cover of the suit and all this other shit, but it was that. Now, you see why they're pot committed? They really want to save these 2023 charges. So they have to say, oh, Kate wasn't involved in that. After you make that argument, stuff comes out about her being involved in that? No, you can't. I'm sorry, you can't come back from it. Forget about uncompromising the grand jury. That's the underlying issue. Kate's role in handling evidence related to the grand jury that Tully submitted with Mello and whatever. That's not this. This, procedurally, you cannot just be like, oh, well, we know Kate helped with the October 2023 indictments or whenever they got bound over December, but we just won't say anything about that. We just won't say anything. You cannot do that. And then it makes it worse when you're like, oh, we'll just no pros the cases where Kate may come up. Bro, this is all for Kate. This is all for Kate. I'm sorry. This is all for Kate Peter. Oh my God. We need a good judge. I don't know who this new judge is. I know his name. I read it at the top, but I don't know who he is. We need a really, really good judge. Because that judge is going to have to make some really tough calls. And this is very bad for the state. This is like perjury level bad. I don't know. Is that how it works? Like, this is we're bordering in some of these misstatements. Forget about the consequence. Forget about the consequence to the legal argument if new factual information comes out that undercuts a core pillar of your argument. Setting that aside, we are bordering on almost intentional misstatements of fact here. There's a little room on some of them for misunderstandings, but we are getting damn near close to intentional misrepresentations of material facts. And this isn't to help Jen McCabe, folks. No. I read that whole thing. This is to help Kate Peter. Oh my God. I'm very uncomfortable with a lot of this. I mean, first, they're fucked. Okay, so Bradel is very good, but he's a Massachusetts criminal defense attorney. He would look at a lot of this shit and tear them apart, all right? But you throw Bederow in there, Bederow knows this factual record probably as good as I do. We probably know different things. But my point is he knows it, and he's a constitutional lawyer. He's going to rip this thing apart. I want to talk to him. Somebody let me interview Bederow about this. Bro, he is going to rip this thing apart. This isn't even a close call. It's not like, oh, I know some of you think, you really want Aidan to be charged, so this is close. Like, here's some arguments for the state. No, it's not close. This is the most... How do you write a fucking motion as the state, as a prosecutor, that damns your own case? What the fuck? And to do it to help Kate Peter. Why? Oh, they're so boned. Yeah, it's a motion response, so I don't think there's actually an affidavit in this. There are affidavits referenced JI-5, but I don't think he submitted. Oh, fuck, he did. Cosgrove submitted an affidavit. It's just under seal, so we can't see it. All right. What the fuck, man? I'm so uncomfortable and upset, and I see it all exactly now. We need to trace out a little bit more who exactly was working for Kate Peter, who was a mole. But this motion tells me everything, bro. Like, oh my God, they spared no expense, and they fucked up too. You're gonna have the best lawyer in the fucking world. You can't predict the future. Oh, this is wild, Greer's Garden. Great to see you. Hi, 3 Clerk Monty. Yeah, the judge. Trust me. If there is a judge, I believe the judge in this case has integrity, who comes on and sees this. Oh my God, it is going to be. Yeah, this is not even in the realm of like what is it when you do like a voir dire challenge to a witness? I forget the name of that. Lumen Martin hearing. No, that's something else. That's when you plead the fifth. I remember that for the Kearney hearing. What was the one with Dr. What was her name? Dr. Russell. They did some kind of motion hearing where they inquired of her, and it was to determine her competency as an expert under 7.1 or whatever. And that was a close call, okay, when you're interpreting whether or not someone is a like qualified to be an expert witness and render opinions on certain areas. That's always a close call. This is not a close call. All right? Like, this is, you can't make these kind of legal arguments and have it come out that your material facts are wrong or that you're making misrepresentations. You can't. You're already on such shaky ground with these arguments because they're not good arguments, all right? Like, he's wrong about a lot of this stuff on the facts about Kate Peter's involvement, the extent of it. We're not dealing with the issue of, like, was Kate Peter sending innocuous material. We're dealing with the question of whether she had agency as a government actor, all right? Well, he won't, or what you're saying. No, JA5, I disagree. I think this was written. They missed the filing deadline. New information came out. They had no choice but to go with what they had. They didn't have time to edit this. This was due like 6 days ago. They wrote this. Cosgrove wrote this. All the new information came out countering everything, and they just said, all right, it's already written, it's due. They had probably had meetings about it, which explains the leave to file this late. You realize Cosgrove's not even guaranteed to get this heard. Cosgrove missed the deadline. He had to file a motion for leave to file late. I think they had to have a meeting and decide whether or not they were going to file this, notwithstanding the new information. Listen, Cosgrove must be at the end of his career. I'm telling you, you can't get past this. You can't. Ethically, I don't even want to begin the analysis, but just on the merits, this is going to be so bad. Unless that judge is in the bag, I don't think so. I have no reason to believe that. But I'm telling you, this is incredible. It's simply incredible because, again, Bederow already did a supplemental affidavit that was filed before this thing even got filed. That supplemental affidavit alone undercuts like 90% of the most important part of Cosgrove's argument about Kate Peter's involvement in the handling of evidence related to the 2023 indictments. And folks don't understand, those were handed up in December of 2023, which was simultaneous with the start of the grand jury for the charges that got handed up in February or March, whatever it was, of 2024 against Aidan. Those 2024 indictments are now dismissed or null pros. The factual record ties it all together. Kate Peter was never not involved. And now Cosgrove's going to have to go in there and be like, oh, you know, Judge, well, I guess Kate Peter was involved in the 2023 cases. Okay, well, if you're a judge who read this, you're immediately going to say, but wait, your entire argument was that you don't even foresee her being a witness in the 2023 cases, so her contact with the DA or her bias has nothing to do with the integrity of the grand jury proceedings. Was she or was she not involved with the 2023 grand jury proceedings? If she was, then that's a material issue, and clearly you told me in your motion, Mr. Cosgrove, that there was no involvement in this case, the 2023 indictments for Miss Peter, that would lead you to need to call Miss Peter as a government witness. And now I see this email from Kate Peter to Ken Mello saying, per our conversation, X, Y, and Z about a legal strategy. About the whatever timing it was. It was in December, maybe earlier. Really? Coincidental? Not coincidental? Nonsense. Nonsense. This is bad. I could stand here all day and tell you how bad it is, but this is going in a way I did not foresee at all. And that's why Kate Peter and all her crew are so pissed at Lindsey. Clearly, they were going to try to mislead the court. You can't mislead the court. That's naughty. That is, somebody get Auntie Deb. Auntie Deb, Kate Peter's been being naughty. Her and the Norfolk DA were trying to mislead the court. Naughty, naughty. Yes, JI5, it was put before the court in Bederow's supplemental affidavit, which indeed is evidence. It also included the contacts between Kate Peter and Ken Mello related to the 2023 cases that are now at issue, and that came out in the last week. It was filed. We've reviewed it previously on stream. Okay? So maybe what we'll do is on Friday we'll read both of these back to back. We're not doing it now. I got to go eat lunch. I got to go do things. I have a life. But I'm kidding. You all are so fun to spend time with. But how about that? How about that? That is some crazy shit. I finally put it all together. Listen, it's kind of Occam's razor if you think about it. Like, of course it's Kate Peter. But to see it so blatantly, and the nice part is I would be a lot more incredulous if they were just arguing this shit, and then I was like, oh, you don't understand, folks, you don't understand, you gotta believe me, there's this, this, and this. No, Bederow also already fucking sandbagged him. So I'm like, oh, this is gonna be a fucking shit show. So the Bederow put an supplement, so JI5. Bederow submitted a supplemental affidavit. In the supplemental affidavit was reference to the evidence the Kearney defense obtained related to Kate Peter talking to Ken Mello. There's no affidavit about that. Bederow himself wrote the affidavit, which is under penalties of perjury, and attested to receiving the evidence, thus submitting it into the record through the affidavit. So it's not just Bederow saying something. He's saying, I obtained this piece of evidence. I'm attesting to it in an affidavit. Here's the evidence. There's no second affidavit attesting to the evidence. They don't need to do that. They have the actual email. All Bederow needs to do is attach it and then put in an affidavit that he got the evidence. That's the evidence. It's Kate Peter's own email. It's not someone saying, I heard Kate Peter did this, or someone told me Kate Peter did this. No, it's the email. So it's in the record. Michigan Meg says, hey, Grant, I'm just late, but I just printed the motion to read it myself. I'll have to rewind so I can hear your analysis. Yes, Michigan Meg, you're only about 20 minutes into the analysis, so you go watch that DVR as you're reading along. It's 26 pages, and I'm pleased to tell you, you don't actually have to, you should read it, but it's mooted. As much as this talks about the section of Mello's, about Mello being mooted, that's not even really that relevant. Mello's clearly sick, but that's a whole different story. It's related to, I think Ken Mello has cancer. So that's another thing, folks. Get mad at all the people you want. Like, Ken Mello definitely has cancer. So just keep that in mind, right? Let's just try to keep that in mind. The other thing that's going on is, and I say that because I remember being at a hearing like a year ago, and one of the Turtle Riders who knew something about Ken Mello's family was like, hey, like, don't attribute this to me. They didn't say I couldn't tell people. I just wanted to let you know Ken does have cancer. You know, I know his family, and I don't want to say this publicly. They didn't want to, like, look like they were defending him, but they also were like, I don't care, I'm telling you. They were like, Grant, that's why I'm telling you. I want people to know, but don't tell them it was me who told you. And that's my right. I have a right to do that. But anyway, one of the Turtle Riders was like, no, he really has cancer. So if even someone who was a Turtle Rider was telling me Ken Mello had cancer like a year ago, he's definitely sick. Let's keep that in mind. But my point is, when you read through this, what you'll end up seeing is that it is just incredible, the lengths that folks went here to protect Kate Peter. I don't understand it. I am absolutely baffled. JI5, I think it was an attorney can file an affidavit. Correct. Yes, JI5. Bederow's supplemental affidavit contains evidence that contradicts Cosgrove's response to TB's motion, but Cosgrove's response was still filed, nonetheless, a late file, indeed, knowing that there was evidence. I can't get into Cosgrove's head and be like, I know that he read Bederow's supplemental affidavit before filing this. I don't know. Maybe he did, maybe he didn't. I would imagine if he's doing his job, he did, but I can't confirm that. I don't talk to the dude. But the point is, yes, notwithstanding whether or not Cosgrove knew about Bederow's supplemental affidavit, Cosgrove filed this document, which was contradicted by a document already filed with evidence. It's the craziest thing. It's like, I don't even know how to explain it. Like, I get there's some legal nuance to it. I'm not a lawyer. There's not legal advice. So you have to understand the procedure of it all to see how bad it is. And now I had moments when I was reading through this when I was like, oh, damn it. This is why lawyers are the way they are. Because this crazy shit happens. And then you want to be like, don't you see how crazy this is? But then you have to translate it like 4 steps for people. Because you're like, oh, like to someone who's trained, I'm not a lawyer, this is not legal advice. To someone who's trained, when you're seeing this stuff in emotion, you're reading it differently than someone who's a lay person. You're reading it like with the rules in mind. That's the best way I can explain it. Like every sentence I read, I have this like index of rules that I'm checking it against. So like I have like the discovery rules. I have the rules of criminal procedure. I have all the cases that interpret those different rules. I'm thinking about all of that. So every sentence you put in a document, I'm cross-referencing against, did you violate this rule? Did you violate this rule? Did you break this rule? Did you conform with the obligations under this rule? What about the interpretation of the rule? What about the update to the rule? Are the cases that you're citing in line with the newest version of the rule? Are you citing good law? Did you shepherdize this? Are you actually talking about the material facts? And then that's one component of it. But then to take it to sort of the larger picture here, you then can inductively think about the strategy when you realize this whole motion is about Kate Peter. You kind of strip away some of the legalese and the performative Oscar Wilde quotes and the 5 redundant references to the movie Casablanca. Cosgrove must really like, I can see Cosgrove now sitting there watching Casablanca. Listen, I love the damn movie. Vultures everywhere, you know what I'm saying? But it's not apropos to, I am insulted by how he referenced Casablanca, because he was like, Kate Peter may have been sending Brian Tully, it may as well have been stuff about Casablanca. No, bro, that is a terrible analogy. Don't degrade one of my favorite films. It's not as good as Being There from 1970 whatever involving Peter Sellers. It's not as good, Peter Sellers. It's not as good as some of the Kubrickian canon. But if you're going to invoke Casablanca, the film that got America through the war, my word, Mr. Cosgrove, the least you can do is use it in a manner that involves some type of literary flexing. And saying it 5 times in a row just to be like, okay, Peter could have been sending something innocuous is not good enough. If you're going to use a film for that, use something worthy of Kate Peter like Shrek. Say, Kate Peter was sending Brian Tully clips of the movie Shrek. And you know, let's read the sentence and replace Casablanca with Shrek, actually, and let's see how it sounds. That's why people turn in, I'm telling you. Forget about erudite commentary from a lay towel. No, you want to hear me replace the Casablanca sentence with the word Shrek before I go eat lunch. Yes, this is what the people want to hear. Casablanca. We're calling it Casablanca. All right, hold on. We got to find the Casablanca part. This is how people in law school talk, too. They're like, oh, you know the part of the opinion about Casablanca? That's the Casablanca part. You got to have a shortcut. We're changing every reference to the word Casablanca to Shrek, and then I'm going to read the sentence again, just because fuck Kate Peter. I don't trust Obach's motives per se, but she really doesn't like Kate Peter, at least ostensibly. She makes a lot of funny posts about her. All right, where's the Casablanca part? Please just get me the Casablanca part. The fact that there is a Casablanca part, I think he italicized the word Casablanca too. I really appreciated that. That was a nice stylistic touch. But at a certain point, I was like, sir, how many times can you reference the movie Casablanca in a single paragraph? Were you doing a marathon of Casablanca that weekend? Were you really thinking about the way that Northern Africa played into the tension between Free France and the Allies? You know, oh, here we go. All right, okay. It's right here on page 19. So we are going to who plays Shrek? Hold on. Who voices the character of Mike Myers. Okay, ready? Here we go. For example, if someone sends an unsolicited email saying that a defendant looks a lot like Mike Myers and attaches a link to Shrek, is it sufficient simply to save the email, or must the Commonwealth download and preserve a copy of Shrek? Does the content of Shrek constitute part of the statement of the witness, or is the statement simply her own words? Or her own words and the fact of her attaching Shrek, irrespective of the film's actual content? When the link goes dead without any action by the Commonwealth, has the Commonwealth lost evidence or destroyed it? Come on, this is outrageous. It's outrageous. Fucking outrageous. First of all, they weren't talking about Casablanca, bro. What, they slipped, fell, and then they weren't talking about the case. They were just watching Casablanca. And then they kept slipping and leaked the phone extraction. Oh, yes, they were just having a great weekend at the movies, learning about American history and the pantheon of domestic film production. And they chose Casablanca as the movie. It was a complete happenstance, Judge. You don't understand. Kate Peter, who's Kate Peter? She's clearly an informant about Casablanca. Yes, the Norfolk DA was recruiting people to go around with their Discord operatives to learn about the movie Casablanca so Kate could send summaries to Brian Tully. I put it all together. That's it. I have put it all together. Write it down. Ladies and gentlemen, write it down. Tell your friends. It all makes sense. Yep, no, it was a complete misunderstanding. Kate Peter was just helping the Norfolk DA learn about the movie Casablanca. Brian Tully needed summaries. He didn't understand it. It was so complex they had to bring in Robert Cosgrove. There you go. All right, laid out. Listen, call that quantum epsilon dolorum, all right? Stated as proven, all right? Put me in the towel history books. I have thus proven it. Yep, that's it. That's the explanation. Oh, yeah, and then, of course, he made a fucking typo. Look at this. He's like, why would Kate ever send exculpatory material to Tully? Bro, the argument is that she sent fucking evidence of her bias. The other thing is, Cosgrove calls it fexculpatory. Now, I don't know what fexculpatory material is. I was a little bit worried where he was going with that Latin root there. I was like, oh no, that can't be evidence involving that, right? But there's a little X in there, so I'm hoping it's not that root, you know? It took 70 days for Cosgrove to watch Casablanca. Oh, all right, listen. Michigan Megs, you definitely earn a wrench for that. I understand. See, what Cosgrove meant to say at the end of his filing regarding why he was late is he was trying to watch Casablanca, but it took him a long time because he had to keep pausing and taking notes so he could understand why Brian Tully was assigning Kate Peter to watch the movie and send him summaries. Absolutely innocuous. They all just love Casablanca and Humphrey Bogart and that wonderful song, what is it? As Time Goes By. You can't hate on that movie. It's a really good movie with a redemption arc, but you got to think of yourself from the perspective of, does it make sense? You got to think of it from the perspective of, does it make sense? All right, that Brian Tully and Kate Peter were emailing about the movie Casablanca, or does it make sense that Brian Tully and Kate Peter were emailing about Kate Peter's role as a PI involving the Aidan Kearney investigation? If you think the latter is more likely, then the Commonwealth's going to lose this motion. If you think Brian Tully and Kate Peter were just talking about Casablanca with Ken Mello, then the Commonwealth's going to win the motion. All right? That's the most basic that I can make it. Now, I don't think a lot of you think that it was about Casablanca. That's not what they were talking about. Do you know how I know that? Because immediately after this Casablanca, we're calling it the Casablanca motion. Immediately after the Casablanca motion gets filed, evidence comes out that Kate Peter and Brian Tully and Ken Mello weren't fucking talking about Casablanca. Now do you understand why it is serendipitous? It is fate manifest. Democracy. You want to talk about democracy manifest? One, I want some chicken. Two, this is democracy manifest. All right. My name is Grant Smith Ellis. Thank you for watching. Did you find that informative, insightful? Do we have questions? Let's open a time for questions. All right. We have 10 minutes for questions. I'm ending this at noon. That gives me a little bit of time for me to eat before I got to go do towel things. So let's take questions. If you want to support the stream, you know exactly how to do that. Did I drop the donation links earlier? I think I did. If I didn't, I'll drop them again now. If you learned a lot today, feel free to support independent journalism. I assure you, Kate Peter and her people are mocking me very hard right now, trying to take away a lot of my ability to sustain myself. I think it is because I'm onto it. All right. And I think a lot of what I've said is bearing truth. I didn't want to say this because I wanted to get clout or resources. I wanted to survive long enough to tell this story. And because of some of you, I've been able to do that. So if you want to help me get a nice little lunch, get some calories in me before I go over to do my towel work, I'm going to try to work a few hours today. There you go, being a productive member of society. You can find the donation links down there. Obviously, it's a public information service and designed to educate, inform, and entertain the wider public. We use entertainment as a hook here in order to engender cogent public discourse and ward off the usurpation of our representative forms of government worldwide. You don't see a lot of independent public information services anymore, and you get everything on this channel, from court coverage to document coverage to analysis to regulatory coverage to breaking news and more. And if that's the kind of thing you want to see continue, then it's viewers like you who make it possible. Yes, I may have learned that from PBS, but the point remains the same. If you don't want to see sponsors, which I don't have, if you don't want to see shadow networks of control impacting what you see on your screen, the best way to help Little Towel is to be the change you want to see. But yeah, you got to think kind of like the Comey indictment getting dismissed. If someone has a question about the nature of the Odell or McCarthy standard or DiBenedetto standard, you'd have to really think about the nature of the prejudice. So it's not just was there prosecutorial misconduct or something, it's did it impact the fairness of the process. And at that point, it's not just what was Kate Peter doing. You can get over that. It's did the Norfolk DA over 2 years try to keep that from the public and the defendant and the court. That you can't get over. Ball game. I don't mind sponsors if they're like a good family-owned company. Yeah, I would consider it, by the way, Nunya. Like, if people have some ideas, or if you're out there and you own a company and you want to see your logo up on the screen, you can't have editorial control, but I would absolutely be interested in highlighting you for my platforms. I think we're at like 100 million plus views per year total and impressions over all the platforms. It might actually be 100 million plus just on X, at least over the past 18 months, probably like 140 million. And then on Instagram, it's a lot now. It's like 100,000 a month. And then on LinkedIn, which is really hard to get traction on, it's like 1 million a year or something. I don't know. The point is, a lot of people are reading what I'm reading. I think we're in like what I'm writing and saying, or seeing what I'm producing. I think we're in like 156 countries as well. I think most of the viewership is in the United States, but we have a lot of people in the UK, Australia. There's different marketing opportunities, I suppose. It's about 74% women that watch the program, 26% men. I don't think any of you are under the age of 18. I don't even think there's anyone under 24 that watches, according to the analytics. Most of you are between 24, 48. Some of you are older, but yeah, it's an interesting crowd. Alicia Ricci says, you're a very smart, Grant. I went through NCDAO corruption in 2023. They go after vulnerable women. To protect their CIs, I need help writing an affidavit and will pay well. Well, unfortunately, I'm not able to do that. I wish I was at that point. I'm just a Little Towel. But if anyone sees the call for help there, it's definitely in the chat. And by the way, I totally believe that the Norfolk DA is not going to run for re-election, and that it will be Adam Deutsch who takes that position. Michigan Megs, yes, the Cash App is # Grant Smith Ellis. Nunya's like, does that mean I'm an elder towel? Yes, Nunya. You are not just an elder towel. You are the captain of the good ship Bodie McBoatface. I'm a little bit confused as to why you don't want it to be called McTowelface, but, you know, you're the captain of the ship. Nancy, you are not a boomer. You are a super towel. You can be a boomer and a super towel, but Nancy is wonderful. You're all wonderful. We had a good time today. I'm sorry we didn't get to play trivia. I did not expect a 26-page motion. I did not expect it to have that many reverberations, and I need to go eat my lunch. So, but that said, I'm going to keep taking your questions. I promised you 5 more minutes. So before I do my outro, which, by the way, you know how we're going to do it, I end the same way every time, and we're not going to do that till 12. So you got 5 minutes. Oh, somebody sent a donation. Oh, God bless you. Thank you so much for your support, Michigan Megs. Casablanca, that was indeed a wonderful part of today's motion, even though maybe it didn't make the point that Robert Cosgrove thought that it was going to make. Now I have mental images of Brian Tully and Kate Peter watching Casablanca and then writing reports for it and then filing those with the state police. Clearly a good use of our taxpayer resources. Happy Thanksgiving indeed. You did, Michigan Megs. God bless you. I actually saw that come in on my phone as you said it because I was looking down at the comments and saying, seeing what questions came in. Nancy from the 508 says, happy Thanksgiving to everyone. Nunya says, gobble, gobble. I think Nunya has turned from a ship captain into a turkey. Nobody tell the various animals involved in this stream they might eat Nunya. Ralph, it was great to see you. Hold on. I'm getting Pete Bunny Towel. Ralph, it was great to see you, my dear friend. I've always been a fan of your wonderful username. All right, last call for questions. Towel definitely wants to go eat, and then he's going to go be a productive member of society. All right, last call for questions. Last call. All right, I'm going to my outro, but if I see only during this 1 week every year is Nunya turkey. Oh, by the way, did you know you can vote on pardoning the White House turkey? They put out an app. I don't know which one I want pardoned. Can we pardon them both? As long as the one who is not pardoned gets to go live on like a big farm somewhere, we just can't kill the one that doesn't get pardoned. I know we have to kill some of the turkeys, but I just don't want to actually be responsible for picking a turkey and the other one dies. I just want him to go live on a farm. Maybe it's a female turkey? What's the difference between a male and female? Do you call a male and a female turkey a turkey? Or are they one of those things where like you call a male one thing and a female the other? I have no idea. I don't know anything about turkeys. Pete Bunny Towel is also baffled. Normally he can help me, but he is an herbivore and he says he's repulsed by the thought of eating another animal. JF5 says, Happy Thanksgiving, Grant and everyone. Nunya says, I think the president should pardon 3 turkeys. Well, Nunya, will make you the president, then you can pardon all the turkeys. I'm not necessarily sure that pardoning all the turkeys is a good idea. What if they become an invasive species? Do you know how many turkeys just wander around the streets around here? You go around, all of a sudden it's a little turkey on the corner, and I beep at it, and I'm like, are you sure you should be this comfortable and conditioned around humans? So I try to yell at the turkeys. Not in a mean way, just kind of telling them, like, you know, I'm a human. You know, I don't think they really understand. Needless to say, if you followed me around for a day, you'd see some very funny things. Mostly me, like, looking at animals. And then I'm sure there's other things that happen. Anyway, my name's Grant Smith Ellis. I think we can do our closing. Michigan Megs, you have a great day as well. All right, so if you've never been here before, I like to close the stream the same way every time. If you benefited from today, if you learned something today, you know I'm going to say there's a way you can pay it forward. JI5 would like to tell us, though, that they would pardon all the turkeys. They are a vegetarian. JI5, Pete Bunny Towel is jumping up and down. He's so happy he found a fellow vegetarian. He would like to ask you if you would like to join his club. It's called the Pete Bunny Club for the Prevention of Cruelty to Turkeys. What? All right. Anyway, he's pleased with you, JI5. Nancy says the turkeys are all over Worcester. 3 Clerk Monty, final question. You got it in before the buzzer. Thoughts on same judge for 1, 2013 WB trial, 2, Farwell's case, 3, matters regarding Proctor TUI material, KR versus everyone. Oh. Well, first of all, what's the Whitey Bulger trial? Oh, wow, it's the same judge? Is it Judge Casper? It's got to be a senior judge, probably, if they were around for everything. There's probably something to the fact that they're all being tried together, or by the same judge, though. Very good question, 3 Clerk Monty, though. Very good question. I appreciate it. We'll keep an eye on that for sure. The federal cases related to those materials all being tried by the same judge does have some relevance. I don't know what it is. I think it's Judge Casper, but I don't remember, so don't quote me on that. Yes, Alicia, I agree. All right. Nunya is curious about that federal judge. I am as well. All right, so my name's Grant Smith Elvis. Let's close. I got to go eat. Traditional closing. Oh, first of all, let me just say hi to people in the chat. We had Nunya, 3 Clerk Monty, Alicia, JI5, Nancy from the 508, Michigan Megs. It was great to see you. Holy Ralph Male Empire. Again, Captain of the good ship Nunya. Michigan Megs, it was great to see you. Who else popped in here? I saw JI5. Greer's Garden. It was good to see you. Nicola Cox, our dear friend who I initially thought was from Scotland, who's actually from London. Then I found out it was another Nicola who was from Scotland. So what are you going to do? Young Black Economist, thank you so much for popping in. Had a good time chatting with you today. Really appreciate your insights. Let's talk about the Federal Reserve sometime. Lauren M., thank you for popping in the chat. Who else do we have here? Bunny was here. Bunny got through her Thanksgiving shopping. You do it, Bunny. Absolutely love it. Hello, Ducks. It was good to see you. Tanya Vincent, my dear friend, you believe whatever it is your heart believes. We'll see how history plays out. God bless you for stopping by. Christina, my friend, it was good to see you. Always appreciate your compassionate discussion. very good to have you. You as well. Believe whatever you want to believe. The facts will play out as they do, and we'll still be here talking. Auntie Bev's alongside. God bless you. Such a handsome turkey towel. I am a little handsome. All right. Allie, Towel, and Rue were here earlier. Sorry we didn't get to play trivia. I had a motion. I knew it would come in. I knew it was going to be big, and it was. Troy was here. Good to see you, Troy. LS was here. Good to see you, my dear friend. Oh, we had a lot of towels popping in and saying hello. And, of course, Nancy was here as well. Marvin Hagler asks, who will win, Belmont or Watertown? Isn't Belmont, first, I only really track BC, but Belmont football is just notoriously terrible, so I say go with Watertown. I probably should vote for Belmont, seeing as I'm from Belmont, but we were pretty terrible when I played as well, so. All right, towel friends. But yes, Marvin Hagler, thank you so much for stopping into the stream. Let me end the same way I end every day. Oh, 3 Clerk Monty, I saw you in there as well. If you benefited from today, if you learned something today, if you liked this stream, if you found it informative, here's how I really want you to pay it forward. Look for reasons to do small acts of service and kindness, ladies and gentlemen. It can be something as simple as donating to our homeless veterans. I truly believe there should not be one veteran in the United States of America who is homeless against their will. Shame on the scar on the face of the country. Shame on all of us. They want to go live in the woods. That's fine. We're not going to stop them. Not one veteran should be homeless against their will. You can help by donating to charities that support our homeless veterans. Second, what if you want to support animals, like Pete Bunny Towel? You can donate to an animal shelter run by veterans. Maybe it's an animal charity that trains service dogs for veterans. Either way, you can help animals and help veterans. Now, what if you want to help animals and you can't find a service shelter run by veterans? That's okay. You can donate to an animal shelter or find another way to do so. That's a great way to pay it forward this holiday season. But it can also be something like donating to The Big Issue if you're in the UK. That's a great charity that helps populations experiencing homelessness get back up on their feet. Nicola, oh, I'm so sorry. Yes, so you can watch the replay. You absolutely can join the replay crew for this one. You'll find a lot of the information, I think, to have been helpful. Sorry we can't do a full day stream today. I'm actually going to do some work later today, hopefully. So there you go, being productive, and I appreciate it. Where I left off, though, was you can donate to The Big Issue in the UK. It's a great way to help populations experiencing homelessness. But it can really be something as simple as waving at a friend or family member, waving at someone on the street, saying hello to a friend or family member you haven't heard from in a while, or even donating 200 tomato plants like Francis Frutrell did one time and having them designated as honorary towels forevermore. Yes, in that way, ladies and gentlemen, I believe we can change up the current realpolitik from one centered on preserving, expanding, and demonstrating our power to instead one centered on preserving, expanding, and demonstrating our capacity to engage in small acts of service and kindness based in unconditional love. I believe it's possible because of you all, ladies and gentlemen, and I think we'll bring about, through those ripples of kindness, a new digital epic defined by Aquarius the Water Bearer standing tall and carrying a towel. My name is Grant Smith Ellis. I'm hungry. Nicola, it was great to be able to add you with a towel wrench. Nicola says, hi, Grant. Good job with law school. UK has a Dogs Trust charity. I love it, Nicola. You just either send me a message on Twitter or find me. You let me know the name of that charity, and I would be happy to share the name of it at the end of every stream. That would mean a lot to me. But yes, Towel Friends on the X. It's Thanksgiving in the U.S. Even if you don't celebrate Thanksgiving wherever you are, happy Thanksgiving from me and Pete Bunny Towel to you. He's going to eat a lot of lettuce. I'm going to eat some turkey. I hope you all have a wonderful time with whoever it is that you spend the day with. If you need someone to talk to tomorrow, you just reach out to me. If I see the message, I'll respond. You know where to find me, Instagram, Twitter, X, whatever it may be, all Grant Smith Ellis. Or you can email grantsmithellis@gmail.com, and I'll find you as well. I really appreciate the time we got to spend together today. We'll see each other probably Friday, if not Friday. I think Friday's looking good. And I'm looking forward to that. So I'll have more updates, I'm sure. If something big happens, I doubt it. Between now and Friday, you'll see me. If not, I will see you Friday. Hopefully nothing will happen on the holiday. It's not a holiday for people not in the U.S., but it's a holiday here. Happy Thanksgiving indeed. So, Towel Friends on the X, God bless you. Be well. Enjoy the beginning of this holiday season. Merry almost Christmas. Get ready for the Christmas music. It's coming, and no one's going to stop it. Pete Bunny Towel's very excited. My name's Grant Smith Ellis. Be well, Towel friends on the X. Enjoy the rest of your Wednesday. Happy Thanksgiving Eve. Until we see each other soon, Towel loves you very much.